Hey, I'm Brian Beutler, Senior Editor at the New Republic.
And I'm Yevgeniy Feyman. I'm Deputy Director of the Manhattan Institute Center for Medical Progress.
And we're going to be talking, I think, exclusively today about King versus Burwell, the Supreme Court decision that came out on Thursday that upheld Affordable Care Act subsidies in 34 states. I guess I'll kick it to you, Yev, and let you kind of say your piece on this.
Sure. All along I was kind of on the fence about this. To be frank, I thought the plaintiffs had an interesting argument from a statutory perspective. Policy-wise, I worried about the implications of getting rid of subsidies in 34 states. So I'm not upset about this ruling. I think more than anything, I'm happy that we can move past these judicial exercises. But what's interesting here is the court not only left the subsidies in place, but they also effectively preclude a future administration from going back and trying to re-inject some kind of ambiguity into the language. So for now, I guess we're left with the status quo.
Right.
More or less. And what do you think?
Yeah, I mean, there was a finality to this decision that didn't exist back in 2012 after NFIB. I mean, NFIB was sort of tailor-made for future mischief, right? Like the mandate half of the ruling basically said you cannot use the Commerce Clause to do certain things. So it sort of cabined the Commerce Clause in a way, and then also obviously it said that the way the law's Medicaid expansion was written was unconstitutionally coercive. So that had a huge impact on the coverage expansion, the Affordable Care Act, but also it expanded the court's coercion doctrine, right? So now new lawsuits are being tested to see whether under that ruling, federal powers can be diminished. This ruling, it was sort of expected that one way or another it was going to include some kind of thread for conservatives, for Affordable Care Act opponents to pull on, to say, all right, we didn't win this case, but we can at least use this ruling as the starting point for something else. If they ruled on constitutional avoidance, to say that the challengers' interpretation of the ACA would have been too coercive by threatening to destroy insurance markets in states, well, now we can challenge the Clean Air Act or something like that. Or if they had ruled and accorded deference to the IRS, said the statute is ambiguous, so we leave it up to the executive branch to interpret it, that would have been all good and well until Jeb Bush or somebody else comes into office having promised to turn off the subsidies on their own. What the ruling basically says is the deference standard doesn't apply here, because even though the provision in question has ambiguity to it, the statute as a whole is very clear in its purpose, and it would be contrary to the letter and the spirit of the whole law for a future president to turn off the subsidies on the basis of the term exchange established by the state. So it's over. I mean, there's no way for this ruling to really be used against the Affordable Care Act or against other big federal regulatory laws. And one of the things we were looking forward to discussing is like, what's next? Like, what's the next chapter in King? And I don't think that there is one. I think it's basically over.
Yeah, the impact of King is pretty much nil at this point. I think you make some good points about effectively most judicial avenues are closed off now, and what's left now for Republicans, for other reformers, is basically going to be legislative changes,
right? Which is as it should be, right? I mean,
exactly. You shouldn't be waiting around for the court to make changes if you want to see changes being made.
I mean, especially in a realm like healthcare policy, right? Like we saw what happened when the court kind of made policy in NFIB. I mean, there's this coverage gap, which is, sort of, in my opinion anyway, like a tragedy for the millions of people who fall into it. But it screws with hospitals that were sort of part of this grand bargain in the Affordable Care Act, where they, lost some payments, but they got more customers, for lack of a better word.
Right.
And so they're suffering as a result. But Republicans are so entrenched in their opposition that they're not really lobbyable on this point. So we just have this screwy status quo that doesn't seem to have any solution, and then it's because the policy wasn't made by a legislature; it was made by the court. And I can't help but thinking that John Roberts wanted to avoid something like that, to basically say, all right, you guys, you had two shots to use the court to upend this law or whatever. Go out and win some elections, right? And you do it. And you can't really mind read, but that closing paragraph or two in his opinion, where he's talking about the limited role that the courts have and that we need to defer to the legislatures when we know that the legislature did something. We can't pretend that they didn't do it. And I think that was kind of like a message. Like, this law is very well understood. We all know how it works. The constitutionality of it has been upheld. So you're out of options unless you go out and win an election and amend, replace, repeal the Affordable Care Act. You're not going to get any more out of us. And I kind of think that's it. I don't think that Jonathan Adler and Michael Cannon and that cohort are going to have much success if they try to find another technicality on which to take a run at the thing. But I didn't.
I'm not sure there really are any
right.
Any other technicalities. I'm not a lawyer,
right?
So I guess I'm a little limited when I say that, but there's no indication that there's any serious challenge that can be brought
right.
to make it past district courts or the appeals courts.
Can I ask you something? Because I take it that some of your colleagues were a little more sympathetic to King than most of my colleagues probably were, right? Or than I was. Can you key us into the mindset about proponents, the people who supported the lawsuit, not we have to adhere to the law. This is about the letter of the law and executive overreach and yada yada yada. But just in terms of their feelings about the Affordable Care Act, why they saw this as such a promising avenue for attacking the law, and what they were looking forward to on the other side of it. Because I admit to being a little bit mystified. I generally To me, the textual question doesn't. I don't assume it really animates almost anybody who supported the lawsuit. They supported the lawsuit because they didn't like the Affordable Care Act. But for me, you take the constitutional test. It basically passes, and then you from that point forward, you try to change the law via the political process, because using the court. Like the aftermath, if they had won, would have been, it wouldn't have been something that I would have looked forward to, waiting in if I were an opponent of the Affordable Care Act. So when you talk to them, what was the promise of King? What did it really look like to them? Because from my perspective, it's very hard to see what the positive upshot of it was going to be.
And so. The people who tend to support King here, I think a lot of them were certainly animated by the textual interpretation. Jonathan Adler, at least, I think for him this was really an exercise in trying to establish what is the right way to read law, especially a law like this. And a lot has been said over about it being just over 4 or 5 words over the small statute. But in Scalia's dissent, he points out something like 7 or 8 areas where an exchange established by a state is referenced, whereas other parts it's not. I think there's this somewhat ideological bent to interpreting things really in as close a reading as possible, if that makes sense. And that's not to say that you're ignoring other elements of the law. And as Scalia, he's not simply an originalist. He's a textualist. He's well known for really looking at other parts of the law, just not quite as much as the liberal judges on the court. And then I think that definitely animated a lot of supporters of King. I think to some extent. This was seen as a kind of last fight on Obamacare. I think that was a mistaken view, but for many Republicans, for many of the folks more on my ideological side of the spectrum, every fight almost is kind of the last fight, because they see it as once you get past this, it's just going to keep going. It's going to keep steamrolling, and changes basically aren't possible until possibly 2017. They see the administration as being, for the most part, unflexible, as not really wanting to negotiate with states, and that's I think what drove a lot of the support. For
so what I hear you saying is basically like, if there's an opportunity, seize it, because otherwise this thing is going to be far more entrenched by 2017. The political prospects for upending it or for dramatically reforming it are going to be pretty dim. And so even if this was going to create a mess and it's going to be on us to clean it up, and our movement is going to be blamed. It might even politically empower Democrats to some extent. It's worth it because it breaks the status quo in a way that might, in an unpredictable way, redound to our benefit, where after everyone pours into the breach to address the sort of chaos that a King victory would have created, that maybe you end up with a law that's, a little less expensive or a little less complex or something than the Affordable Care Act. I guess I can see that. I just feel like I understood why NFIB happened. I just didn't really. If I'm thinking like as trying to put a political operative hat on and figure out what's the best strategy for unwinding ACA, I would have been really wary about this from the outset. And I guess it takes having lived with a certain level of antipathy to the ACA for going on 4 or 5 years now to really kind of understand how important it is to people who don't like the law to find any lever possible to sort of break the status quo and get the process of unwinding it started. Is that fair, you think?
For the most part, I do think it's about more than politics. As I briefly mentioned, I think the ideological slant here is also to a different way of reading the law, a different way of reading statutes, which it's a very deeply seated, deeply held belief. Whether you agree with it or not, and that kind of stretches beyond just the ACA, beyond this immediate case. I think it stretches to reading law, reading statute, reading the Constitution more generally.
Can we actually take a little digression and talk about that? Because by sheer coincidence, right? Libertarians, conservatives, they like on a procedural level, sort of narrow readings of bills, textualism, avoiding the atmosphere surrounding legislation, like that's their preferred method for interpreting statutes, and I think that there is like a profound logic to it, just in terms of like epistemologically speaking. How do we right? But it is like it's worth commenting upon that like a libertarian like Jonathan Adler, the three conservatives who dissented in King, they selected an interpretive mode that like seemed to be chosen for the purpose of right. Like it's not like Jonathan Adler's out there scouring every sentence of the tax code and every other healthcare statute out there looking for an anomaly like established by the state, because he's so committed, right, to the precepts of this kind of textualism that he wants to make sure that all right. It was the Affordable Care Act, and it was they found something that they thought could be useful to that end, and at the end of the day, the decision was made because the cornerstone basically of the majority opinion is that in addition to saying through an exchange established by the state, it also says that if a state doesn't establish an exchange, the secretary will step in and establish such exchange, and that's basically the whole argument, right? It's a substitution, right? Like if I write a law that says everyone in America shall have a dog, but for the purposes of this statute, a dog shall be defined as a domestic feline, right? Like that's like a really circuitous way of saying that we're going to give everyone cats, right? But it's clear, it means what it means, and that was the whole case, just a direct substitution. And I sort of can't help but think that, like, in general, across law, across politics, that people aren't super committed to, like, procedural technicalities, like whether you look at this much of the statute or because those four words are so clear you don't look further around them, and they tend to use what modes are available to them to reach outcomes they think make sense, right? Like, heuristically, what makes sense to Scalia is like taking away subsidies, and heuristically what makes sense to John Roberts is not, making a mess like that, and he knows what the law was designed to do, et cetera, et cetera. So you find your mode that gets you there. And I just, maybe it's just like, I can't help but feel like King kind of pulls the veil back on how much BS there is in the way, like, lawyers and judges and so on talk about modes of interpretation and how important it is, because they don't use their own modes consistently. So do you think that I'm wrong? Do you really think that, like Jonathan Adler is like, this was like a really bad day for textualism? Like, I think he was like, no, it's like a really bad day for conservatives who wish the government wasn't so involved in healthcare, right? Am I wrong?
I think it really is a little bit of both. You're right that people aren't going to be scouring every single law to ensure that it meets the requirements of how they read law. They're not going to be looking for a reason to challenge every
right.
single statute. When they discovered that there might be possibly something wrong with it, that a close reading of the statute would invalidate it.
Right.
Sure, but people go after laws that they disagree with.
Right.
And that's kind of the nature of our legal system. You have to have some kind of harm, but also you don't just say, well, Supreme Court, go read every single law we have and make sure that they're consistent with your particular approaches to reading law. So I think there's some truth to what you're saying, and it's kind of like in macroeconomics you have Keynesians and you have for the more free market types, and Keynesians tend to be more liberal.
Right.
Types tend to be a little more right wing, and it does naturally conform to their ideologies. So the same thing here. I think there's a little bit of selection bias involved.
I think it's a little bit of it's selection bias is part of it, but I think it's also like a sort of natural, and it's not even a bad thing. I'm going to use the word opportunism, even though I don't necessarily think it's terrible. Just like in the way that, like, in Congress, right? The Affordable Care Act wouldn't have become law without the Democrats using the reconciliation process. And so for 4 years, reconciliation was this, this 4-letter word, 11-letter word, whatever. There's a terrible thing that it's tyranny and it's cramming the law down our throats and yada, yada, yada. And now there's, like, of course, a strong appetite for Republicans to use reconciliation to try to roll back the law. And it's always been this way, right? Like, filibusters are terrible until you're in the minority, right? And that people who have commitment to purpose, right, they use what tools are available to them to achieve the purpose. And I don't think that there's anything wrong with that. I just wish that there was, like, a little bit more honesty from both, from people on all across, like, the ideological spectrum about what they mean, because otherwise you end up, like, detouring down these, like, BS procedural arguments that I don't think anyone's actually committed to. Like, if I were a conservative and I supported the King lawsuit, I would say, screw textualism, right? Like, this is the thing that we can use to and like that's how this whole lawsuit evolved, right? It started with this presentation that this lawyer Tom Christina gave at AEI, where he was like, look, there's not going to be subsidies in states that don't set up their own exchanges, and that's going to create some coercion issues, right? And so they were going to make this constitutional challenge, and then the money started flowing. Like, IRS started subsidizing all the states anyway. So they're like, all right, well, now we have a statutory case on our hands, right? Like any port in a storm kind of approach to pursuing your aims. Like, I don't think it's a bad thing. I just wish that there could have been a more clear discussion about what was going on, because when it detoured down like, oh, this is just about the rule of law. This is, we are deeply, deeply committed to making sure that, that the IRS isn't like reading beyond the bounds of the term established by the state. I don't think anyone really cared about that so much. I think that they really cared about like what they were after, which is important. It's a good thing when people who are committed to goals, pursue them aggressively. But I think that's what was happening, right? Not so much to unfortunately, our grammatical hangups are super important. So these 5 million people who are going to lose their insurance, sorry, but rules are rules. I don't know.
Yeah, I mean, if you're asking, whether conservatives would have brought this case if they supported the law, that absolutely not.
Right.
I mean, I completely agree with you. And like you said, though, it's not necessarily a bad thing. It's good to have some level of this kind of debate. I'm not sure if King v. Burwell went a little bit too far, but having some of this back and forth, even if it's a little bit not so transparent.
Right. No, it's true. It's true. And I don't think it's unimportant, right? Like, I don't want, particularly this court, speaking as a more liberal guy, just kind of, using whatever BS they can come up with to reach the outcomes that they want and then impose that on the country. Like, I think it is important for, there to be some level of consensus about, how it is we know what we know. But I feel like that could, you could run that in a number of ways, right? Like, you don't need to say, always use this very strict kind of textualism, even when we, have all this other information. Like, just ignore it, because in a case like the Affordable Care Act, where it's not some law that was written 60 years ago and all the legislators are dead and we can't really be sure what they meant by this language or that language, like the historical evidence and the evidence in the media, et cetera, that's important for how like we go about saying we know what we know. And like that I'm glad that made it into the Roberts opinion, that like, come on guys, we all know what's going on here. We know what this law was supposed to do. There's a way to read it that achieves that purpose, and that's the whole case. And like, I just feel like that's like just a better way of going about, interpreting any law when you have such like clear evidence, like you did in this case. That should be admissible. That just as admissible as the sentences that make up the statute.
Yeah, I partly agree with you. My concern, I guess, is I really don't want to see the Supreme Court or any courts for that matter in the business of trying to make laws with bad consequences into laws with less bad consequences.
Right. I agree with that. I agree with that.
And what's interesting to me, and I'm struggling with this a little bit, is in the opinion, they reference the experience of Massachusetts, of New York, Oregon, I think, in implementing their own regulations similar to the ACA, community rating, and New York, for instance, the laws regulating the insurance markets were devastating.
Right.
They destroyed New York's individual market, and certainly none of the legislators intended that to happen.
Right.
The intent was always to just make insurance cheaper, but still keep people in the pool.
Right.
They just made a mistake when they did that, and they didn't include any kind of incentive to remain insured beyond having insurance. But when you're talking about a $1,000 a month plan for an HMO, only the really, really sick people are going to remain. The legislators obviously didn't expect that. But if the case had gone up to the Supreme Court, if someone had brought a case, I wouldn't have wanted to see the court say, well,
impose a mandate out of nowhere, right?
Exactly.
Yeah, I totally agree with you. It's not, but now, like the history of New York is important to the Affordable Care Act, because like the lesson that Congress took from that was you can't just do the coverage guarantee without the other two legs of the stool. And that's what Roberts was saying. He was saying that, like, we know that they learned a lesson from New York, or from Massachusetts or from wherever, and that's why they structured the law in the way we know that they structured it, and why they wouldn't have structured in the way the challengers say. And I think that like, just as heuristically, that's like Roberts is on much sounder heuristic or epistemological footing, and just saying, what do we know about this law, and not constricting himself to the apparent meaning of established by the state, but looking beyond that. He came to what is, I think, indisputably the correct interpretation of how the law was designed. So I think that even if people were pure about their sort of procedural precepts, that it was possible for not just 6 but all 9 of the justices to get to the ruling that Roberts ultimately came up with, and that nobody would have really had to sacrifice any consistency to get there. But I guess probably Scalia and Jonathan Adler would disagree with me on that. I want to ask you, like, to get away from this kind of boring legal mumbo jumbo, especially since neither of us are lawyers. What you think would have happened if this had gone the other way, and then what do you think is going to happen going forward? Like, what are the options for conservatives now? I guess assuming a Republican president and a Republican Congress.
Right. So I'm a little bit biased here.
Okay.
Actually, what I've been working on a little bit, and idea I've been playing around with, and some of my liberal friends have also looked at this. This idea of the 1332 waivers, these state innovation waivers that exist in the ACA. To me, it seems like that should be the next logical step for conservatives to take. It's in line with conservatives' federalist roots. It devolves more responsibility to the states. This is a big idea conservatives always like to champion, and the idea is that you give states this block grant. It consists of funding from premium subsidies, cost sharing subsidies, Medicaid if they expand Medicaid, and basically let them figure out what to do with it so long as they meet certain requirements set up in the law. To me, that seems like a much better idea than pursuing this single repeal replace plan or or other piecemeal reforms, because you're probably never going to get everyone to agree on a single plan.
Yeah, I was my own sort of thinking, like, what would be the ideal thing to happen if King were to win? Obviously, what I expected would have happened, and what I think would have been the right move politically, is for Obama and Democrats to trumpet their one sentence fix and hopefully just win a technical correction bill, basically, and then the status quo had been restored. But assuming that wasn't going to be possible, I think that advancing the start date for the innovation waivers would have been like a wise, just just détente, right? Like, let's stop fighting about this. Like what liberals, what I particularly care about in the Affordable Care Act is the coverage guarantee, right? Like, as a moral issue, as a opposing free riding issue, as a just like wanting people not to suffer through medical bankruptcy thing. What I particularly care about is that, like, anybody can like be confident that they can get insurance, right? What you build around that in terms of subsidies, or if it's a mandate, or whatever, like whether states run it, whether the federal government runs it, I'm mostly agnostic about, right? And so you have this mess after King, and if what conservatives really care about is more state control, like, keep the coverage guarantee, figure out a way to make it work. Like, I'll take that as a détente if we can just stop fighting about it constantly. And it sounds to me like you're more or less on the same page as I am, but I think that, like, probably my fellow liberals and probably your fellow conservatives generally don't agree with us and would think that, no, let's continue fighting to make this as like painful and awful political milieu as possible for as long as we can, because eventually we'll get single payer, or eventually we'll get, whatever it is conservatives really want in the out of the healthcare system. But why? So why aren't people as enlightened as us? I guess is my question.
I hope you're wrong. My sense is that at least so speaking with policy wonks, people who live and breathe healthcare now, there's at least some agreement that there are things that need to be fixed. That it's still a little bit incomplete from liberals, conservatives, a little bit to the right. They want to see more changes, but generally, I've gotten pretty positive reception to the idea of some kind of block grant, some kind of devolution of responsibilities to the states, within certain guidelines. I don't believe that there's really this massive majority of liberals that just want to see single payer, or that there's this huge majority of conservatives that want to just strip away any kind of insurance coverage and leave people with $15,000 deductibles that they can never afford. They're very vocal. That's a problem. I think those wings of both sides of the spectrum are some of the loudest. But I think there's a reasonable consensus you can assemble somewhere closer to the center, and get enough people on board with it, get enough states on board with it, to actually make some of this a little bit more realistic. Pushing up the date of the waivers. I think that's the first step. Even now, I mean, it doesn't seem like there's any reason not to do it, rather than wait until 2017. Let states do it now if they have a plan. Let them do it in 2016 if they need to wait that long. But having experimentation, I don't think is a bad idea. And who knows? I'm willing to concede that maybe Vermont actually goes and does their single payer experiment and turns out to work much better than anything else. And I'll be willing to concede, well, look, it worked extremely well in Vermont. They did something well. And I think conservatives, liberals should be excited by that.
I totally am, and I wish I agreed with you that if Vermont pulled off single payer, conservatives would be empirical about it and say, all right, well, this worked. It came in under cost. Everyone's covered. It's like much simpler for people because they don't need to shop around for insurance. So we'll just do this nationwide. Like, I don't think that's what conservatives would do. And if denying the success in Vermont was the way to avoid it taking hold outside of Vermont, that's what would happen. I mean, I think that's sort of what we're seeing with ACA is that on the right there's like a real allergy to admitting that it's done anything good. And I mean, it's clearly done something good, and there's many fewer uninsured people in the country now, and that's putatively right, like everyone's goal. Nobody wants there to be so many millions of people without insurance, but at the same time, if I'd like to hold myself to this standard. If a Republican president was able to, modify the terms of the innovation waiver such that a conservative state could go in and be like, "Here's what we're going to do." Democrats are never going to let us get rid of the coverage guarantee. So what we're going to do is we're going to make a catastrophic insurance floor that everyone gets, and then we'll either prefer a health savings account or something like that, so that if people want to see a doctor for things that aren't catastrophic, they can save up for that without being having to pay taxes on it, and we'll kick the very poor a little bit of money into their account every year so that they can also go to the doctor for colds and a checkup or whatever. If they did that and it held costs down dramatically, which I assume it would, and everyone got insured, and the rates of medical bankruptcy went down, and welfare improved overall. I would accept that for the whole country, and I don't think most liberals would, but I would only accept it for the whole country if conservatives turned around and admitted that they only got there because of the Affordable Care Act. So thank God for the Affordable Care Act, right?
I think you'd have a hard time getting conservatives to admit that.
Right, but it would be true.
But I'll say this. I'll qualify everything I've been saying with, I actually wouldn't necessarily want to see it spread across the country. Whether it's the high deductible catastrophic or if it's single payer, because I think single payer might work really well in Vermont. It might work terribly in California or Texas. So single payer works much better in the UK than it does in Canada, for instance. And I'm willing to admit, there are cultural differences. So implementing single payer in Vermont, you're going to have much more support. You try to do it in Texas, you're going to have much more opposition, and that plays such a huge role in getting these policies to work. So, experimentation. It'll work. This works in Vermont. This works in Texas. Let them have their separate systems under this, broader scheme that sets, these minimum floors and ceilings within which these different experiments operate. And maybe some states will say, hey, we want to try this because it's worked well in Texas or Vermont, or maybe we want to try something on our own. And maybe what they try on their own works really, really well there, or maybe it doesn't. That's kind of what I want to see. I'm okay with not creating some kind of single template for the entire country, because for frankly, each of the states is almost their own country.
Right.
When if you compare them to Europeans, for instance.
I kind of go back and forth on whether I think that our there's advantages or not to our federalist system, and whether having all these laboratories of democracy really makes sense for something like health insurance, where like what happens if you have 50 different universal healthcare systems in each of the 50 states? Like you have a single payer plan in Vermont, but you're on vacation in California, and your Vermont Care card doesn't have any doctors in network in California. Like,
it makes it much more difficult. Interestingly, I mean, this is what we have with our existing insurance.
Right. To a lesser degree, because if I'm traveling in California, right, which that's where I'm from, and I have my Aetna PPO card, it's not ideal if I break a leg in California, but it'll be okay, right? Like,
yeah.
But if I'm from Vermont and I have Vermont Care and I break my leg in California where it's controlled by, I'm probably screwed, right? Like, or I got to fly back to Vermont, like with my leg bones sticking out of my right. It's a little screwy, and we don't Americans, we don't travel abroad a ton, but we travel within the states a ton, and don't we kind of increase the risk people take when we fracture the system so much?
Yeah, absolutely. I think you're always going to have some risk with these fractured systems. That's it's part of the trade-off, right, of federalism. I think there are probably ways to minimize that. Travelers insurance is probably useful there. Some kind of mandates for. I'm not sure how it would work. Maybe some kind of negotiated rates. So if you're covered by Aetna in New York and you travel to Vermont with a Vermont Care single payer, maybe require Aetna to negotiate certain rates that they'll pay providers in Vermont, and New York could do that, or Vermont could do that. You could have state compacts. It's not easy.
It's tricky, but it's doable, and it sounds
introduce a different set of problems.
And it sounds like you're hard at work on that, right?
Well, first let me get the 1332 waivers, then we'll see.
So we're recording this on the same day that the Supreme Court also made marriage equality a national thing, and for that reason, I have reporting and other duties that I ought to be attending to. But I wanted to maybe give you a one last shot, either a closing thought or a question for me or anything like that.
I think I just want to. I actually really want to get this out there. I think this platform is great. Honestly, I mean, having the ability to kind of bring someone on of a different political stripe and have this relatively frank discussion is wonderful. I mean, so just a little shout out to Blogging Heads. I guess for you, besides the 1332 waivers, but besides this, and it correct me if I'm wrong, but it sounds like you are somewhat supportive of this, some of this experimentation. What other changes, if any, would you want to see?
Well, I mean, like, if I'm thinking towards liberal ends, right? You know,
Sure.
if I'm Hillary Clinton, then I would probably run on incorporating a public option into every state market, or a single national public option, or something like that. I might do something. It's tricky because I'm not sure that there's like a great way to do it, but maybe smooth the function of the insurance subsidy so that you don't have these phase-out zones where there's like the huge disincentive to make any more money at 200% and 300% of the poverty line. I'm not sure if smoothing the function would eliminate the work disincentive, but it would probably mitigate it somewhat. I've kind of, I was a math and science major in college, so I've always kind of thought we should have continuous functions in our tax code more than we do. So those are two things. But so I want to say two things. Like that would be, a public option type thing. Kind of try to migrate this towards something like Medicare for all is what I think should happen to the healthcare system, and I wish conservatives would just go hide in a corner and just deal with it. But I know that's not going to happen. And even though this is like sort of against my interest as a journalist, where like political conflict is part of the reason why I'm employed, I see things like 1332 waivers as useful, not because I think it's like necessarily the best idea to have, like we were talking about, such a fractured system, but because it seems like there's a small potential there for some kind of détente, right? Like, there are a lot better things we could be doing with our time than arguing over repeal bills, replace bills. Like obviously the parties are super far apart in terms of like how they would structure the healthcare system if they had total control over the government and there were no veto points or choke points or anything like that. But if like Democrats could say, or liberals could say, a lot of our goals are being met, the uninsurance rate is going down, we want to advance that goal to get it down as low as possible. And if getting cooperation from Republicans towards that means that we sacrifice some of the things that we can, that you might describe as luxuries within the Affordable Care Act, in order to get to just a place where we could go back to arguing about taxes or something like that. I think that would be good. I think it would increase capacity in our political system to address other things. Like we're so stuck on healthcare, and for good reason. There's a lot of money there. There's values at stake. There's the country's fiscal situation. Like I get that it's going to be an issue, but I don't think it needs to be quite as apocalyptic as it has been for 5 years. And so if there's a way to use something like innovation waivers, or like my liberal friends are going to make fun of me for saying this, if there's some grand bargain that could be achieved that takes the healthcare conversation down a notch to where we like agree on enough stuff that we can put it in the background a little bit, I would be all for it, because I think that that there's other things that we ought to be at each other's throats about. So I guess if I could go that way, I would, but I assume that it's just going to be partisan warfare forever. So public option plus, whatever else, make the subsidies more expansive, really piss off conservatives. I think that's it. I think that's where I would go. All right. Well, it's been a pleasure. Yeah, good talk. Thanks to Blogging Heads for having us, and let's do it again sometime.
Absolutely.
All right. Bye, Yev.
Take care.